Yeah. So that's a very trusted individual. And most little girls, if a daddy puts their arms around them, it's because he just adores them. And from what I could read, she had to trade you quid pro quo. If she did something, even in the way of the pictures, um, that's how she would get something from you. Is that the way it worked?
We are about to watch the parole hearing of a monster, of a man who did this to his stepdaughter. Now, this case, we actually have the entire appeal because he went to trial. He was found guilty by a jury, and yet a judge felt, even with all of that, that he would only get 15 years, if you can believe it. We're going to hear from the survivor today, and then I'll unpack it with the details of the appeal at the end.
Would you give your name and DOC number, please?
My name is Roger Allen. My DOC number is 578158.
You're a first-class offender. The offense is aggravated incest molestation of a juvenile. Your sentencing was December 10th, 2010. The sentence was 15 years with the Department of Corrections, each count concurrently. Your parole date is 6/14/23. Your good time date is not eligible. Your full term is 9/13/25. Do you have a questionnaire in front of you?
No, sir.
I'm sorry. Forget that. Okay. I'll be handling your case today. And do you have a statement that you'd like to make before we start?
Yes, sir. In 2007, I was addicted to hydrocodone, alcohol, and I smoked the occasional joint. It's not an excuse, it's just a fact. I was, even though my inhibitions were down, I still had control of my faculties. I knew right from wrong. What I did was repugnant and reprehensible. It 5 pictures destroyed everything. It destroyed my family, it destroyed my marriage, it destroyed my relationships, and it destroyed any trust that I had built. It's taken a long time for me to learn to forgive myself, and I can only hope and pray that somehow, some way, she can learn to forgive me as well.
Thank you. We have an opposition this morning. Ms. Nomi DeVille, is she with us?
Yes, Your Honor.
You can speak, please.
Do I speak to you, the court, or do I speak to Roger?
All of us are listening.
Okay. Although I appreciate, Roger not admitting, but apologizing, I guess, or maybe some type of remorse for what he did to me. I'm sorry.
Take your time.
I'm sorry. I didn't think that. I apologize. I didn't think that it was gonna affect me so many years later. My relationship with my entire family is ruined still. Even though Roger was convicted and the evidence was presented, somehow he was able to convince my entire family that I was a master manipulator at 15, 16 years old. When really all I needed was someone to protect me, which my mother and Roger failed to do. Roger gained my trust, and I eventually looked at him as my father because my own father was fighting his own demons. And as a child, I was desperate for a father and a family. And all I got in return was sexual abuse. And I felt he took my privacy away from me. He took my entire family away from me. I feel severely affected to this day by what he has done to me. He speaks about how he lost everything. It was nothing compared to what you made me lose as a child. And although me attending today and speaking how I feel on this matter, he's still getting out next year no matter what. And I feel like it's just not justified. That's all I want to say. Thank you.
Thank you so much. Thank you. Mr. Rogers, I'm handling your case. I read your case. I went through it very thoroughly. I see that you've taken a lot of classes to better yourself. How long have you been incarcerated?
14 years.
14 years. As you see, it wasn't a good thing, but I'm not here to talk to you about that. I have no questions, and I'm going to let my colleagues, if they have questions that they want to ask. Ms. Stapleton.
Yes, sir, I do. First of all, I want to commend Naomi for your bravery to appear today before the board. That's very difficult for any victim to do. And we could see your pain and we could hear your anguish over the childhood you lost. So you have my deepest, I don't know, I would say sympathy, but that's just not even the right word. Okay, so let me get to Roger. Roger, at the time this happened, am I correct? You were 40 years old and she was 15. Is that correct?
Yes, ma'am. About
And approximately. And she did see you as a father figure. Is that correct?
yes, ma'am.
Yeah. So that's a very trusted individual. And you know, most little girls, if a daddy puts their arms around them, it's because he just adores them. And from what I could read, she had to trade you quid pro quo. If she did something, even in the way of the pictures, that's how she would get something from you. Is that the way it worked? Like if she wanted to go somewhere or get some money or anything like that, she had to pose for pictures or she had to do something.
No, ma'am, it wasn't like that. I really don't even know what was going through my mind or what. I'm sorry.
Well, we know the pictures got taken.
Yes, ma'am.
As a child, she was finally able to get somebody to believe her. And thank goodness for that, because from what I could read, she tried it another time and nobody did believe her. But she finally did. And she was able to give police the information as to where to be able to find them on the internet. So that proved that what she was saying was true. Am I correct when I say that?
Yes, ma'am.
Yes. And so that is how they came up with the fact that you got the charges. Your original charge was aggravated incest, sexual battery, and pornography of a juvenile. Is that correct?
I don't
Original
know.
charge. You don't know. I got you. But then it was pled down to aggravated incest and molestation of a juvenile, of which you got 15 years for each one of those crimes, but they run concurrent. So actually you're serving just 15 years.
Yes, ma'am.
Okay. Okay, that's all that I have. I think that right now I read that there is extreme opposition from the district attorney and the sheriff for any early release, but even an early release, you're going to get out next year anyway. But that is what they had to say about the situation. All right, I'll turn it over to my colleague, board member, Mr. Prater, if he has anything he'd like to say.
No questions.
Okay,
Okay,
is the board prepared to vote?
I am.
Since I handle your case, Mr. Rogers, I'm going to vote first. I mean, I think I read your case several times, and I congratulate you on the classes and stuff that you're taking, and which I think is good. I see that you have remorse, and that's good. And you're trying to reform yourself. My vote today is to deny. Ms. Stapleton?
My vote today is to deny also. I did see the classes and maybe it just didn't show up, but I didn't see that you took any sex offender class. Am I correct or wrong about that? Did you take anything, a sex offender class?
I've never been in a place that offered it.
Ah, that does happen. Okay, I forgot to ask that question. So yes, my vote today is to deny.
Mr. Prater?
My vote's to deny also, and with the recommendation, if at all possible, that DLC find a place that he can go to for a long-term sexual abuse classes before his release. His release is going to be next year anyway, so let's try to get that done if at all possible for the Department of Corrections. Thank you. Deny.
Thank you. Mr. Rogers, your case has been denied. Your parole has been denied, and I wish you luck. This concludes this case. We're signing off. Thank you. At 9:51.
Can you even imagine his opening remarks? What he says is, it destroyed my family, it destroyed my relationships, it destroyed the trust I had built. I pray she can forgive me. Are you kidding me? Mr. Tillis actually says at the end, I see you show remorse. I see you took programs. The guy didn't even take a sex offender program. This, he described his crime as repugnant. This roach is repugnant. The judge that sentenced him is repugnant. To run the sentences concurrent, he should be serving another 16 years, not 1 year, as Richard noted. And we'll go through the appeal. Can you imagine? He went to trial. This wasn't a plea deal. He went to trial. He put the state through the cost of prosecuting him. He put his victim on the stand. And when a jury finds him guilty, the judge thinks that 15 years is enough? Why? Let me sit down across from that judge and say, really, Judge, sir, why? To what benefit? For what reason? He drags the entire, he makes everybody go to trial because he denies his guilt. He wants to continue to prove that he is innocent. He's being wrongfully accused. And then when a jury finds him guilty, the judge is lenient with him. Make it make sense. It's like finally a DA says, we're going to go and prosecute. And then it's the judge that just says, I don't care. It's just a child. Who cares? So let's go through it. All right. The defendant was charged with the amended bail of committing from December 2007 to 2008 one count of molestation of a juvenile when the offender has control or supervision, and one count of aggravated incest, count 2. The defendant pled not guilty on both counts. Following a jury trial, he was charged on both counts, and on each count, he was sentenced to serve 15 years of imprisonment. But the judge, in his wisdom, or her wisdom, decided, if you can imagine, to run them concurrently. So it's just 15 years. First of all, the legislation allows for more than that for these crimes. You can get, I believe, up to, it depends on the they call it crime against nature, incest charge, up to 50 years. In some cases, the maximum is 20 years. So I'm not sure which one he's fell under, but 15 is the minimum that legislation says you have to get. So the judge went out of his way to give the absolute minimum sentence. Why? No one with any common sense no one can give an answer that would justify that. Why, Judge? Why? Seriously, why? And then the next thing I would love to know is why the DA felt that they can only bring these 2 charges. When you go through the appeal, you're going to see that they could have charged him with manufacturing of CP. They could have charged him with distribution of it. They could have charged him with he does. What we're going to go through this appeal is insane. I mean, it should have been full on sexual assault. I don't know why they didn't bring those charges. So the fact of the case, after the victim, the survivor, testified that her stepfather, she testified that she had left her mother's house and then moved in with her biological father for a few months because the defendant was being inappropriate with her. She stated that when she was 13 years old and in her bed with a headache, the defendant came to rub her back, but started to rub her on top of her shirt and then under her shirt. And this is just the beginning. She kept telling him to stop, but he would move her hands, on her. The victim indicated that a few days, a week, the defendant would, I'm not going to read this out loud, but basically full-on assault. The victim testified that after she moved back in with her mother and the defendant would grab her. According to the victim, the defendant also showed her pictures of naked girls and women. She alleged that he showed her porn on his computer. She also stated that the defendant wanted her to wear lingerie-type outfits and cut a long black tank top just below her breast and then cut a slit in the front of her shirt. Additionally, she testified that the defendant kept telling me that he wanted to lay behind me naked and telling me that he wanted to have sex with me and he wanted to do the other acts. She stated that when she was 15, the defendant continuously asked her for naked pictures, and he took some pictures of her when she was naked. She indicated that the defendant put the naked pictures on his computer. She identified State Exhibit 3, which included numerous photographs of a naked or partially clothed young girl, as photographs of her. I mean, this is why didn't they not charge him for creation of producing child CP? Why? Why didn't the DA bring that charge? I don't understand. She stated that she copied the photographs from the email the defendant had sent out on his computer and then distribution of it. This is insane. SB also testified at the trial that now here's someone else they're bringing in. This is another victim. Because the initial victim goes by the initials of ND, and now this is SB. So they bring another victim. She's older, but she indicates that the defendant was 4 years and 3 months older than her. She stated that she had known the defendant all her life. Her mother and the defendant's mother were best friends, and she lived in the same house with the defendant for 3 or 4 years after her mother moved from the divorce. She testified when she was 8 years old, the defendant, so when she was 8 and the defendant was 12 and a half, the defendant would wake her up in the middle of the night, take her into his mother's room and tell her to sit on his lap naked from the waist down and try to penetrate her. Additionally stated that the defendant would take her into his room to make her give him sex. And so this is part of the argument saying that this wasn't relevant. They couldn't bring this up. But and it is quite interesting that but as you can see, this guy has been doing this stuff for forever. SB further testified that when she was 9 years old, the defendant took her into her mother's bedroom and penetrated her to the fullest. While sitting on his lap, she started to bleed and she got up. The defendant said, "I popped your cherry." She also stated that when she was 9 years old, the defendant took her into the garage, made her undress from the waist down, and made her sit on the lap of one of his friends. The defendant told her to be a good girl. The defendant knew SB was, and she had sex with his friend. SB testified that on another occasion, the defendant and his friend Scott held her down in the bed while Scott's older brother, I mean, He conceded he received a bad conduct discharge from the Navy for burglary. What a shock. He also conceded that he had made a video of his wife having sex and put it on his computer. He also has nude photos of his wife on his computer. However, he denied grabbing the victim. He also denied taking the pictures of her. So it is interesting that they were able to bring that up. I get that's part of his appeal, but other crimes and assignment of error. Number one, the defendant argues the trial court erred in allowing the state to admit evidence of other wrong acts concerning the alleged incident that occurred over 20 years earlier when the defendant was a child, because the defendant unfairly prejudiced his case. I mean, I do hear that as a legal argument, how that could be relevant. I mean, he was also a child. The presumption of innocence and improperly supported the victim's credibility. Relevant evidence having any tendency to make the existence of any facts the consequence. Okay. I mean, it's just like another, it's just, I don't really know why the DA would bring that, but I guess I'm getting distracted by this appeal. The bottom line, facts of this case is that he was found guilty. The judge could have sentenced him much more. And then even when he gives him these light sentences, he runs them concurrent. Are you kidding me? It's insane. It's insane. It's madness. And it was nice to see, Miss Stapleton, the victim's advocate, to say such kind words and to be so supportive. It makes a big difference. But you probably wouldn't believe this stuff if you didn't see it. And you have the monster on one hand, but then you have the system. You have a judge that really, you can clearly see, does not care about protecting the community, about protecting children, about the most simple things that I think so many of us would just see this and say, wait a minute, why are you giving him a minimum sentence? This wasn't a plea deal. He went to trial. He cost he made the state prosecute him. Why reward him with a light sentence? Anyways, with that, I'll let you go.